dealing with a matter of their child.
Good morning, my lords, my lady. I appear on behalf of the appellant mother in this matter. May I begin by introducing...
So sorry. Yes, I think I did. I'm so sorry. My clerk will stay here while we just do housekeeping, because she's puzzled by my bundles, but... sorry, do carry on, Ms. Ackley.
Not at all, my lord. My lord, I was going to begin by introducing the other parties present in court.
Yes.
I, of course, as I say, appear on behalf of the appellant mother. I'm assisted by my junior, Mr. Sham Uddin, who appeared on behalf of the mother in the lower court.
Yes, I assumed that was him. He hasn't actually found his way onto the advocate sheet, but okay.
So sorry,
Yep.
my lord, that
No problem.
wasn't there. But in addition, my lord, I have with me those instructing me, my instructing system, Mr. Dmitriov, who sits behind me, and the mother, Mr. Dmitriov, and the mother sits at the end of the row, and beside her...
Well, I think we're not using names, are we?
I'm so sorry, my lord.
Yeah.
And beside her are two support workers who are present. My learned friend, Mr. Wilson, appears on behalf of the father who sits at the back of court as well. The child himself is not represented at this hearing, but my lords will be aware that a document has been filed on behalf of the child by counsel who represented him at the lower court. I will in due course, my lord, come to that document if I may. Before I go any further, may I just raise one issue in respect of practicalities, and that is with regard to the mother and her presence in court today. My lord, I understand that the mother, as my lords are aware, is on medication, and that medication at times has an impact on her physically. She may need to just rise and leave the courtroom as and when required. She hopes that she'll be able to be present throughout, but with my lord's permission, may the mother just be excused.
Oh, she doesn't need our permission, but of course we quite understand if she has to leave, and people can come and go as they,
Indeed, my lord, I appreciate it
as they wish. But of
open
course,
court.
that's well understood. Thank you.
My lord, I appreciate it's open court. I raise it as a matter of courtcy.
Yes, no,
This is
thank
the
you.
mother's hearing.
So that's understood. Can I just, sorry, so that I don't keep my clerk here indefinitely. I have a single bundle. It's possible that last week, without thinking, I put 2 or 3 bundles together, but it runs to 598 pages, and an authorities bundle. Is that your point? Yeah. Yes. We haven't got the authorities bundle. Could you go get it?
I've got 2. I've got 2, but they're different.
Yes, you want the one with the proper reports in it.
The longer one.
Yes, there was a problem about the authorities bundle, which I'm not to give anyone a hard time about it, but can whoever was responsible for putting them together just make sure their clerks or whoever did it know that's how we want them. This is in the practice direction.
I apologise. I
It
hope
couldn't matter less, but it's just worth making the point because we get it rather too often.
Indeed.
Right.
I have the point.
Now, yes, Ms. Ackley.
My lord, my lordships and my lady are seized of the issue of the mother's appeal, which is a single and narrow point. Permission to bring this appeal was granted by Lord Justice Peter Jackson on the 1st of April, and my lords will see that the document at 92C, which is electronic 102, as the order of my lord, if I could invite my lord to have a look at that document.
Yes, I've actually taken it out so as to have it.
Yes.
Yes.
My lords will see that permission was granted by my lord, Lord Justice Peter Jackson, on the 1st of April, and very helpfully his lordship distilled into that order the 9 examples that were put forward on behalf of the mother as the examples that would be pursued at this appeal. And rather than the manner in which it's set out in the skeleton argument on behalf of Mother, my lord, I think it would be more of assistance if I used this as the framework.
Yes, we were assuming you would.
Yes,
that would be helpful.
Most grateful, my lord. may I say from the outset that in relation to those 9 matters, that the mother is unable to pursue the first example because we have no transcript in relation to the August hearing
2019.
2019, indeed. And so, Lord,
Yeah, sorry, I confused myself. Yes, I thought for a moment we have, of course, we have one from
March
2021,
yes,
yes. Yes, my Lord, it is completed, but
we don't.
we
Okay, so
have
one
that.
not pursued.
Yeah, one can't be pursued. I should say, as the mother wishes me to, that there is some sense of disappointment on her part that we don't have that. It's not through lack of endeavour of those instructing me who sought that transcript to show that this wasn't an isolated occasion. The mother will say that difficulties arose. It simply hasn't been obtainable.
Well, we can't go into it without knowing it, but it is clear. We know the judge found the mother, although unfortunately doesn't accept it, but found her to have lied in various very serious ways. But this must have been something separate from that.
It is.
Yes,
Yes,
I
it
see.
is.
But since we don't know what it
Yes.
is,
My Lord, I'm not going to trouble you further
Well,
because I
okay,
can't
look.
advance the point.
Thanks.
But my Lord makes an accurate observation. And furthermore, whilst, my Lord, we are looking at those matters, I don't intend, on behalf of the mother, to pursue number 6, not allowing the appellant to have regular breaks during the proceedings in the August 2021 hearing. My Lord, of course, we reflect upon evidence and the proportionality of pursuing issues. In reflection, my Lord, we say that albeit that the breaks weren't at the level that was initially requested, it's clear from the transcript of the exchange between counsel and the judge that agreement was reached about the frequency of those breaks, and those breaks were indeed provided. So, my Lord, I don't pursue that.
yeah. Well, thank you, if I may say so. I think that's a very sensible decision.
Thank you, my Lord.
While we're just getting the framework of your of the appeal clear, I note that Lord Justice Peter Jackson's first recital on page 92A. If this appeal succeeds, the effect will not be to lead to any overturning of a previous decision, any previous decision, including the decision in the judgment in August 2021, but merely, I say merely, it's important, that the judge would not hear the final, what's listed as the final hearing later this month.
Yes.
That's right, isn't it?
Yes, my Lord, it is right.
Can I ask this? The reason why a decision about the outstanding matters has been delayed is because we were waiting decisions about a prosecution.
Yes, in short.
Have those decisions, or that decision, been made?
The short answer is that the CPS have made a decision. The longer answer is that that is being further reviewed now through the victim review process. And so there isn't an ultimate outcome because I understand that that will potentially take a little longer for them to
Right.
reflect.
Do I infer from that the decision is not to prosecute?
Yes.
Right. Are the parties agreed that in those circumstances it will be possible for the court to proceed, if assuming the court can sit, the court can proceed to make final decisions in this case at the end of May?
Yes, certainly. So
You're not going to ask for a further adjournment?
No. So far as my position on behalf of the mother is concerned, forgive me, the mother's position, she wishes that hearing to proceed. This is, as my Lord is aware, an old case.
Absolutely.
And she has not had meaningful contact with her son for some time. And in those circumstances, my Lord, we'll see that there are directions for the filing of evidence impending, coming up very soon, the 8th for the parents, the guardians soon after that. And my understanding is that His Lordship on the 1st of April had indicated that there would be a backup tribunal that he was going to consider in the event that the appeal was upheld. I'm not sure if that's happened. I know that Mr. Wilson has made an inquiry through his clerk this morning to find out if there is a listing with the clerk of the rules, and the preliminary indication is that there isn't, but we might have that entirely wrong. but that is what had been anticipated, that there would be a backup tribunal in the event we were successful, so as not to cause delay by that method.
Well, clearly this case needs, when I say so, this case needs to be resolved. It's been going on for a very long time.
Yes.
And it looks as though efforts have been made to ensure that whatever happens on this appeal, it will be resolved by the end of this month.
Indeed, yes.
Thank you.
One hopes so. Thank you, my Lord. Lord, yes, and so of course, going back to my Lordship's order, permission was granted, and His Lordship very helpfully, as you have seen at 92C, assimilated what this case is about, or what it is that the mother raises in her appeal. And my Lords, all the mother seeks in this case, if I may very briefly say, by way of introduction of the grounds of her appeal, it is a fair hearing. She seeks a tribunal that will listen to her and her arguments in the same way and in equal measure to the arguments raised on behalf of the father. She does not believe, my Lords, that she will receive a fair hearing before His Lordship, Mr. Justice Keehan. And I'll come to, in a moment, the basis upon that. My Lord is quite right to say that she hasn't sought to appeal findings. Her focus in this case is to rebuild her relationship with her son and to advance that relationship, as my Lords will be aware. His Lordship, Mr. Justice Keehan, transferred the residence of that child to the father, and the issues, as I understand it, for the hearing in May will be for final determination, final insofar as any Children Act application can be final, but a final order in relation to the contact with his mother.
Child.
I'm so sorry, my Lord, forgive me, the child. And in addition, the contact the child will enjoy with his siblings.
Yes.
So those are the issues.
Is there an issue about a family assistance order?
There is an issue at the moment about the family assistance order, and there have been significant difficulties in the progression of contact, such that I think it would be unfair for me not to alert the court to the possibility that there may be an issue about whether residence is transferred at that hearing again. There is no application before the court at the moment.
It's possible mother may revive her application for a change of residence.
I think the highest I would put it, my Lord, is that it is possible. But of course she'll take advice and she'll reflect on the professional views in relation to that matter. But it would be wrong to not raise that as a possibility. Lord, then coming on to the examples of what is said by the mother to be occasions of bias. If I may begin with number 2 in the mother's schedule. And that is the issue of His Lordship casting doubt on the mother's medical diagnosis in early 2021. Strictly speaking, I don't think it's accurate to say that he was casting doubt on her diagnosis. The issue was more in relation to where the state of her treatment was in early 2021. And I intend, my Lord, I think just to clarify at the outset, because of course in the documents and in particular the position statement that's filed for the hearing of the 25th of March, which becomes controversial, there are many references to the mother suffering from cancer. And in fact, the condition that the mother has is a non-malignant tumour, so it isn't accurate to say that it's cancer. There was no intention, I hasten to add, to mislead the court in any way, because of course the mother was filing medical evidence before the court in any event. But there was perhaps a misunderstanding because the mother was obviously under the cancer unit, being treated in that way, that the actual tumour that she had was non-malignant, and the references to cancer are strictly inaccurate. The treatment, however, that she has received is akin to the treatment that would be given to...
Chemo.
Indeed,
Yeah.
a cancer patient, yes. The condition that the mother was suffering from is fibromatosis, and my lords will be aware that the evidence would support that she had kept that to herself in the early part of 2021, and her reasoning for keeping that to herself, my lord, is set out in her statement before this court. Her statement at 512C, that's electronic 525, paragraph 5 of that statement. She says, in terms, I've been worried about disclosing my condition to the court, and that the other part is, as I didn't wish for it to be used against me or used as a reason for not being able to have contact with a yarn.
Can we,
Oh, I'm so sorry.
frankly, so I'm not making more of a point about it, I don't think it matters enormously because we're not dealing with, in this hearing, with sensitive matters. But I do think we need to be, the rule is that we are not using names, we must be careful about doing it, particularly as this is being live streamed.
I understand. I'm so sorry.
No, but perhaps I should say for the record that nothing should be said which published by people observing beyond this court, which might draw attention to or permit the identification of the child. Sorry, Ms. Anstey, I didn't want to put you off your stroke, but it is important.
No, of course it is, and I fully understand. It's very difficult to, when I was quoting directly from the statement,
No, I
continue to revise
please
it in my
don't.
mind, but I must do so, and so forgive me.
Yes. Yes.
Yeah. You go.
Yes, and so the mother gives her her reasoning in her statement. Just, if I may, just track through those events, because, my lord, I say they're relevant to what transpired before his lordship at the hearing on the 19th of March. It is that before that hearing on the 19th of March, there'd been a pre-trial review on the 16th, when the court had indicated that there would be a hybrid hearing in this case, the hybrid hearing being the hearing of the 25th of March. And at that hearing, what was proposed in exploring the process of that hearing was that the parents would attend the court in person, and the court indicating, therefore, of course, that the mother must attend the hearing in person. And so the issue that she had kept to herself about her health became relevant and was now engaged. Counsel on her behalf sought to indicate obliquely to the court, and this is in the judgment at 516, electronic 531, that the mother was shielding and she couldn't participate in the hybrid hearing. And so the issue didn't come out openly and fully at that point in March or the 16th. But we can see from his lordship's judgment on the 19th of March, when he references the fact that he was then provided with 2 letters, which were sent to him confidentially.
Sorry, could we just have the reference for that?
Yes, of course. The judgment is at 516.
Yes.
And
Oh, I'm so sorry. It's the same. I'm being slow. Yeah. Which paragraph was where the other reference is in?
Forgive me, may I just turn to...
No, I have it. I have it now. No, that's fine. I've got it. It's the second and third paragraphs.
Indeed. And my lord will see that there is reference to the 2 letters. Those letters don't appear in the bundle, but we have a sense of what it was that was being provided to his lordship at the time, because he says so in terms in his judgment, that he had a letter from the hospital about the mother's diagnosis, and he had information about her appointment on the 19th of March. And going back, if I may, a step, before that hearing, the mother had filed a statement with the court on the 18th of March, making a request to adjourn the final hearing on the 25th and 26th of March, and my lords will have that at paragraph 2 of 512B. And so by the time the matter came before his lordship on the 19th, the mother had put in her statement and was making a formal request to adjourn. His lordship had the hospital letter about her diagnosis and her appointment on the 19th. And at the hearing on the 19th, his lordship gave the judgment that is before my lords now. And within that judgment, I draw my lord's attention to a reference made at 516. Which I say supports the mother's growing concerns, and that is the reference that says, in light of the background of this matter, I'm very suspicious that she'll be starting chemotherapy today. The prospect of her starting chemotherapy today, I doubt.
Well, the context, the background to which the judge is referring, Miss Ankler, is quite a clearly established background, isn't it? It's findings that the judge had made in his two previous judgments.
My lord, I accept that.
Including that your client had, is it fair to put it this way, tell me if not, fabricated allegations of domestic abuse.
My lord, that is what he found.
And also his findings about the conception of the twins.
Yes, my lord, he did find that. However, even though his lordship made those findings, he had before him the documents that I've referred to, and it doesn't follow, and it must be, in my submission, right, that simply because he had made those findings, that he would be open to express the level of suspicion he did about the mother, about everything.
Well, I'm sure, with my lord, that that's part of the background he was referring to, but I think he was also referring to the immediate background, that this was the first time that any question of chemotherapy had been raised.
Yes.
And it wasn't mentioned in writing, was it?
Yes.
That's the point.
Yes, no, that's also correct, and of course I accept as a fair point, but nevertheless he had information before him that this lady had a serious diagnosis and that she had treatment at the hospital on the 19th for that diagnosis. And yet the learned judge is expressing the view that he is suspicious that she's even starting that chemotherapy. My lords, I would submit that that is a high accusation indeed, and even set against the findings that his lordship had made historically in the proceedings at that point in time, and even set against the more short-term concern, to say openly in his judgment that he's suspicious that she's even starting the treatment, or the prospect of her starting that. It is a high allegation indeed, and in my submission...
He needed to explain, didn't he, why he was making a decision not to adjourn the hearing.
Yes.
And if those were parts of his reasons, he had to say what they were.
Of course, I entirely accept...
You're really saying that this was not a conclusion he was entitled to reach on the material before him.
That's what I'm saying. I'm saying, my lord, that he of course needed to explain his reasons, and he could have done so entirely neutrally, without casting aspersions on the mother. He could have said, I simply don't have enough information to make that conclusion. In fact, he does go on in his judgment to say, I don't have enough information. But it could have begun and ended there. Neutral statements, fair observations. Of course, any judge is entitled to have or want to have before him full and sufficient material. But what I submit is in the course of this judgment, of course, my lords don't have the transcript of the August hearing, and I haven't been able to pursue the August 19th hearing, so I can't now say, well, there's a course of conduct going on here. But even looking at this in isolation on this occasion, I submit, and my lords may not accept, but I do make the point, that this was going too far to cast this aspersion on the mother, even though he thought she'd lied about that. Simply because somebody lies about one thing, it doesn't follow that they're lying about everything. And a measured approach was needed. A fair and measured approach was needed because this lady was indeed ill. She was indeed going to embark upon a course of treatment. She did indeed embark upon a course of chemotherapy. She did, in fact, go to hospital on the 19th and have that chemotherapy. So all of it, in fact, in contrast to the findings that His Lordship had made about this mother being a liar, proved to be true. She was doing all of
But
this.
isn't that the point? Wasn't there a subsequent exchange? So all these things, once he had a fuller picture, he backed down and the adjournment was granted.
I
At this
accept that.
stage, he's just saying, you've produced 2 letters from the hospital. Neither of them talks about chemotherapy, and I've got no written confirmation that your course starts today. So I hear what you say about the way in which he put it. But in the end, he was just saying, I'm not going to grant an adjournment based on what I've got here now. And all the points you're making about the reality of the situation, that's all post-dating, isn't it?
My lady, I accept that, and I also accept that he did back down in relation to the adjournment. The point I'm making is that the mother and her perception of what's happening in this case is coming to this hearing in the knowledge that the judge has already concluded that she lied, and I accept that that's a finding and it hasn't been overturned. The point is, and my lady has the exchanges that follow in the August hearing between the mother and the judge about her perception of her lying and what that means in the wider context.
Position statement exchanges, yeah.
Indeed. But at this point, was it appropriate, I asked the question, for the judge to say these things about suspicion when indeed all he needed to say, of course my lady makes a very good point, all he needed to say is, I need more information. Of course he's entitled to all of that. Moving on, if I may please, it isn't entirely clear to me, and those instructing me sitting behind me are not the same solicitors that represented the mother at the March hearing, and Mr. Udin's recollection of this is a little vague, so I try to put this point as fairly as I can, and I'm sure Mr. Wilson in due course may assist, having been counsel throughout. But in reading Mr. Bowes' submission in relation to this point, my interpretation is that the Guardian may have been asked to make, through her counsel, forgive me, or her legal representative, to make some inquiries of the mother's treating physician. I may have it wrong that that didn't occur in March. It may have occurred only in August 2021. And I raise this point, my lord, if I could take my lords to the skeleton argument of the Guardian at page 458.
Skeleton for this appeal.
For this appeal.
Guardian skeleton for this appeal. I've taken mine and put them somewhere different.
So have I.
The electronic reference is 468.
Page 16 of the internal pagination.
Yes, thank you.
458.
And it's paragraph 44. My lords have that. My lord has that. Thank you. Partway through that paragraph, which is the summary of the Guardian's position in relation to incident 2, incident 2 being the judges casting doubt on rather than diagnosis. There is a reference to, although it is accepted that asking a third party to communicate with mother's treating consultants is an unusual step, it should be viewed within the context of incomplete information offered by mother. And it wasn't entirely clear to me whether that reference was in relation to the Guardian's legal representatives being asked to undertake that inquiry in March, because it is clear that they did undertake that inquiry in August, whether it's one or both.
You can't read 44 without reading, it's a summary of the preceding paragraphs. The only reference to such a request is at 42, which is about the August hearing.
Yes, no, I accept that, my lord.
But then, what possible basis is there for saying that such a request was made in the March hearing? Or am I misunderstanding your point?
No, you're not misunderstanding my point, and I may have misread those paragraphs, but my junior, who was present, considers that it was a possibility that was also raised in March, and I put it no higher than that. He doesn't have a clear recollection, and Lords, I simply raise whether it did or it didn't. The fair approach might well be to say that we know it did happen in August, and so I don't seek to advance that it did happen.
What would, suppose we were to accept that the probability is it happened in March as well? What point about bias? I haven't quite understood how this fits into your submission, even if it was established.
Yes, well, my lord, the point is very simple. The point is this, that a third party is being asked to make contact with the mother's treating consultant, and so therefore displacing her own lawyers from providing that information to the court, an unusual step.
All right, but that's not an instance that's relied on. And we see no sign that it was done in March.
My lord, I accept that it's quite possible it wasn't done in March, and I hope I've been very clear about that I may have taken it too high to say that it might have happened in March. I don't want to pursue a point that isn't justifiable. I make that point in relation to the August hearing, and so if my lords please take this point to relate to the August hearing, which I'll come to, of course, in due course.
Right.
That in and of itself, asking the third party, the guardian's representative, solicitor, to make the inquiry of the mother's consultant, it is, in my submission, undermining of her own legal team, who should be able to place before the court material in relation to her health. They had done nothing wrong, and they had placed before the court letters from consultants and treating doctors, and it's somewhat surprising, and that's a point that's made on behalf of the child, somewhat surprising that the judge is asking them to do this. It's not.
Well, Mr. Bow doesn't make it in support of
No.
this ground. This ground.
No, I understand. I understand he doesn't, Lord.
He makes the point to disregard it.
Lord, I adapt that point to say that it is surprising and unusual, and one looks at the cumulative events in this case, it is a feature that concerns. Why shouldn't the mother solicitors, in the usual course of events, be placing before the court material in relation to her health? They had done nothing wrong. They had simply put letters before the court. They had not sought to mislead the court in any way. Why should, and what transpired in August, was that the child solicitor contacted directly the mother's treating consultant to gather information to place before the court.
Wasn't that because the judge just still felt, and you have a better sense of the chronology than I do, but when we get to the next hearing, the judge still feels he doesn't really have enough information, so it's at that point that he asked the guardian to sort of cut the Gordian knot and just get in contact with the consultant directly.
Yes, to some degree that's correct.
But you say that that demonstrates a suspicion, that was a misplaced suspicion, that it was the wrong way to go about it?
Yes, I think in my submission it was the wrong way to go about it, and in part it appears to be that let's get to the nub of it and find out. But the process is that parties put information before the court themselves. The mother's legal team were quite capable of undertaking that task and cutting that knot and getting to the nub of it themselves. And
Well, we're slightly getting, if you're going to come back to this point in August, in relation to August, and you are, I've understood correctly, you are, have I?
I'm not going to come back to it. I've made
Oh,
it
I
now,
see,
and there's no
okay,
point
right.
repeating it.
These aren't adversarial proceedings. The judge is obviously concerned about the delay issue. Is this really evidence of apparent bias?
My lord, I say taken together with everything else that's occurring in this particular case, it was evidence that the judge wasn't trusting the mother or her team to place material before the court in an objective way about her health issues, and that shouldn't have occurred. It should have been the mother's team that was allowed to put that information before the court.
Yes. Is that all on instance 2? With
Lord,
them all.
only to put in context and to be fair in doing so, that of course my ladyship has made this point that the learned judge did of course grant the adjournment. I acknowledge that, and that adjournment is reflected in his judgment, and he did in his judgment of the 19th allow the door to be left open for the mother to file further evidence, and so of course presenting the balance picture, the balance of that. I'm not saying that his lordship, that all that his lordship said and did at that hearing was unfair, but I draw my lord's attention to the points that I've underlined in my submission to date. Of course, my lords, if I could just finalise the point in relation to August, so I don't need to come back to it. My lords have before you the medical statement of the 4th of August at 553, that's electronic 568, which attaches the carcinoma team care plan for the mother and her condition with fibromatosis, benign tumour. So there is some medical evidence in this appeal that reflects the mother's condition, letters from her consultant in July 2021 to the Royal Marsden referring her for a clinical trial. That is at 559, and the evidence supports that by July 2021 the mother, the tumour that the mother had was increasing in size, so a concerning medical presentation in relation to what this mother was bearing. There's reference to her arthritic condition as well at 559. Moving on, if I may, then to example 3 and example 8, if I may take those together because they're interrelated, relating to the admonishment of counsel on behalf of the mother.
Well, they're very different. They have that similarity, but they're separated by time.
Of course. I connect them because...
the reference to the BSB.
Indeed, yes.
But apart from that, there's nothing really to link them.
The connection is that it is that, and the fact that counsel had to deal with it on 2 occasions.
Well, perhaps we have better hear your submission, but if the focus is very specifically on whether it's appropriate for a judge in any circumstances to make such a statement in open court, then that, I quite understand why you're taking them together. But if you are saying that, quite apart from that, counsel hadn't done anything wrong anyway, the circumstances are wholly different. Anyway, let's see how you put it.
Yes, my Lord. Of course, I am submitting that counsel hadn't done anything wrong, and I'll begin, if I may, with the facts relating to the 25th of March 2021. And it's submitted on behalf of the mother that the judge's treatment of the mother's counsel was unjustified and disproportionate, and the way that issue was dealt with, and the issue that arose, we submit, goes to the issue of apparent bias by the judge. The learned judge, of course, threatened to report Mr. Udin to the Bar Standards Board. And that, I submit, was effectively his opening line at that hearing on the 25th of March. And I further submit that there was no proper investigation of how that issue arose. The exchange was very limited, and if I could take my lordship to that, I think it's electronic 100.
Electronic page 106.
Yes, I mean, it's another point for another time. I think it is unfortunate that we have separate page references for paper and electronic? Well, we can cope. You're taking us to page 100 hard copy, is that right?
It's
Yes.
yes, 100 hard copy.
And it's just that one exchange, or 8 lines or so at the top of the page.
Yes. My lords can see that his lordship, almost as soon as the hearing begins, makes the remarks that B doesn't please me actually because I consider your position statement to have been impertinent and impudent, and I should tell you now that if you ever dare file a position statement like that before me again, I'll consider reporting you to the Bar Standards Board. Do you understand? And Mr. Uden's response is, thank you, my lord. My lord, the position statement was done on instructions from my client. And his lordship responds, yes, I'm sure it was. And it goes no further than that. But that opening line and the lack of investigation about that position statement in my submission is very, very unfortunate.
Well, I take your point about the very first thing said in the hearing. But what investigation was required? He wasn't actually going to report him to the Bar Council. He said, if you ever do it again, he made it clear what he disliked, which was the tone of it. And are you saying he should have spelt out in great detail, which might have made it worse, mightn't it?
Well,
to say that this paragraph or that paragraph was inappropriate or badly expressed?
well, my lord, it's a very serious matter, first of all, for any counsel to come into court, begin to present their case, and for the judge to raise this as a serious possibility. I appreciate not on this occasion, but he's putting the marker down as firmly as one can imagine any judge will do, to say that this is a consideration in this case. It puts counsel on...
Don't get me wrong, I absolutely get that point. And, you've seen that both counsel for the father and counsel for the mother don't feel able to defend that. I'm just focusing on your particular point about absence of investigation, because I don't quite understand that.
Yes.
Of course, if you were going to discipline someone, you would have to have an investigation. Here, you just get counsel being admonished, in very strong terms, I've said, but admonished for the tone of something that he has drafted.
Yes.
Tone, perhaps, and content, the two merge into one another. I think they understood one another pretty well as to what the judge didn't like about it. What further investigation was required?
Well, forgive me, my lord, I'll answer that question if I may in a moment, but this exchange becomes highly relevant in the August hearing because it's further referred to. And so it isn't something that comes and goes, it's something that
I do understand all this. I was really only asking a very particular point, and you say you're going to answer that presently, and I'll please do. Yeah.
Yes, my lord.
Can you, sorry, before we move off on this, could you just help me with whether this was the first occasion on which Mr. Uden had represented the mother? Because there had been at least two counsel before, hadn't
Yes,
there?
no, he was present at the earlier March hearing.
Where was there with the adjournment, and we
Yes.
just looked at that judgment that was
Yes,
just
correct.
an informal judgment.
Yes,
Thanks very much.
Yes, so he was relatively new, but it wasn't the very first hearing.
Yep.
And so far as the investigation point is concerned, one knows as counsel that position statements develop in communication with clients. They're not done objectively and independently of the client, particularly in private law proceedings. Clients often want to see the position statement, have an input into the position statement, often amend position statements, and insist on having things put in a certain way.
Well, you have to be careful about that. Counsel is responsible for documents of this kind. Of course, you're quite right. In the old days, when counsel just said what they thought was best without consultation with the client, have gone. But still, they take ultimate responsibility for what they say in a document to the court. And I don't quite see, therefore, what sort of investigation wouldn't we? Suppose it had been said, it were the case that there were things in here which were plainly wrongly expressed, should never have been said. There'd be no answer for Mr. Udine to say, "Oh, my client told me to say that." It would show he wasn't able to distance himself appropriately.
Well,
So I'm not getting into what the rights and wrongs of this. You may want to later. I just haven't quite understood what kind of investigation is required.
well,
Are you suggesting that there would be an investigation of exactly what came from the client and what came from Mr. Udine?
well, Lord, I think it would have been helpful for there to have been a better understanding of how that position statement came about. Perhaps the word investigation is too high. Some further understanding of how this position statement came about. I, of course, accept that council is ultimately responsible for position statements, but my Lord also makes the point, and I pursue that point, that in matters relating to parents, they sometimes want things put in a certain way, and there's a balance to be struck with council presenting the case that the parent wants to present. And had there been some further inquiry, those parts of the position statement that His Lordship might have found offensive, might have understood better as to whether Mr. Udine was simply being impertinent to him and offensive, or whether those parts of the position statement came about because the mother had become exasperated. I'm not suggesting that in the final analysis that it would have changed the complexion of everything in this case, but it was relevant because Mr. Udine was then immediately on the back foot, feeling to some degree intimidated by events in the courtroom, and we see in my submission, I will track that through in the August hearing, where it has an impact on his ability to put the mother's case.
We don't, because we don't have an inquiry, and it's just that exchange, then the case moves on. To some extent, we're left speculating as to what it was that particularly upset the judge. I've underlined, I don't know if you've got the passages in front of you, 91A, paragraphs 2, 3 and 4, and then on 91C, paragraph 19.
I, not in consultation with my lord, have underlined exactly the same paragraphs, but also 10 and 16.
10 and 16.
Yes. Yes,
Okay,
have
I missed 10.
in particular 10 and 16.
10 and 16.
I had.
There we are, you see.
8,
Same.
10 and 16. Let me add. Take it
8,
add.
well, you see how
8, 10 and 16 on 91B. Right sideline.
16. Oh, yes, I don't know how I missed 16. You're right.
Yes,
Right,
10 and
okay.
16 in particular, I would submit, might have exercised the judge in the phrasing.
They probably have to be read as a whole. A mere phrase about weariness
Yes.
could be quite neutral.
Yes.
It's clear with the others that it's weariness as a result of
Yes,
the way she perceives
indeed.
she's been treated.
Yes, exactly. And I don't demur from that. I don't suggest that this was a position statement that was one, for example, I might file or was well framed. I'm not suggesting that at all. What I'm simply saying is that there was not consideration as to how this position statement had come about, and the impact on the 25th was significant of this position statement, because the learned judge was left with the belief that counsel was just being impertinent. And he filed this document with no respect for the court whatsoever, and of course His Lordship was upset about that. And the backdrop that this position statement was prepared for is the backdrop that we've explored already from the 16th through to the 19th hearing, and I'm not going to repeat those points. My lords have them. You're either with me or you're against me in relation to those points, but that was the backdrop, and the mother's exasperation would appear to have come through in this position statement. But of course, moving now, if I may, to the August hearing, that the position effectively repeats itself at the August hearing before His Lordship on...
Just before you leave this document, do you say there was nothing your case is there was nothing improper or wrong about the way Mr. Udin expressed his client's case.
I don't say that. The way I would propose to frame it is that this was a position statement from an exasperated mother rather than an impertinent counsel.
I don't think quite answers my question.
No, I understand, Lord.
So does it? Would you be prepared to acknowledge that there would have been nothing wrong with the judge criticising the way it was drafted, but you say he went too far by referring to the BSB? Is that really what this comes down to on this instance?
Lord, I certainly say he went too far,
Yeah.
referring to the BSB. I also say that he shouldn't have been angry in the way that he was, addressing counsel in that way, even if he considered it to be impertinent. And he should have considered how that position statement came about. Those are the points I make in relation
Well,
to
I think it's pretty clear what he, by his rather pointed reference to "I'm sure you did," I'm sure it was, that his criticism was that counsel did not distance himself properly from the mother's feelings.
That's possible. It's a possible interpretation. And I repeat the point that a balance has to be struck. It's not about counsel engaging in the mother's feelings. He's presenting a case, and if a client, a robust client, wants to put a case in a particular way, then ultimately is her case. And if the mother in this particular case engaged in how she wanted the case framed, for good or bad, that's how it was put.
No application was, am I right, was made to the judge to recuse himself after the third
Not on
instance that you're
this.
denying.
Yeah, not on this occasion. Not on the 25th. No, not on the 25th. May I move on to the August occasion where the bar standards board was raised? Unless my lords have any other questions in relation to the 25th of March. His Lordship deals with this in his judgment at page 52.
That's hard copy.
I'm so sorry.
I've got it. So.
Yes, that's internal page 52 of the bundle. Begins at paragraph 96. Goes on.
No, we have it.
And his Lordship deals with the recusal application from paragraph 96 onwards, dealing with it in this way. After the conclusion of the evidence, but prior to the commencement of closing submissions, Mr. Udin, counsel for the mother, made an application to recuse myself on the grounds that I was biased against the mother. Further submitted during the course of the hearing that I had bullied him, which had risked undermining the confidence the mother had in him as her counsel. Just pause there. That exchange immediately raises the issue of how Mr. Udin was able to deal with what was occurring in court on the 27th of August. He was telling the judge in terms that he felt he'd been bullied. The judge reflects this in his judgment. And then the judge goes on at 97 to relate back to the 25th of March hearing. And my lord, of course we see, as I said earlier, that the 25th of March episode doesn't stay there. It comes into the foreground. So by the time we've got to this August hearing, we have the judge connecting this to be another occasion where there is, for want of a better expression, trouble from counsel. Mr. Udin had filed and served a position statement on behalf of the mother. I considered a number of passages in this position statement to be rude and impertinent in the court. I raised the matter with Mr. Udin at the commencement of this directions hearing. I told counsel I considered his position statement to be impertinent and impudent, and that if I received a position statement like that again in the future, I would consider reporting to Bar Standards Board. So the judge has brought that previous threat of considering reporting counsel to the foreground, and it's back again in the hearing. During the early part of the mother's evidence...
Yes, I don't think this matters. I don't get the impression reading the judgment as a whole that it was the judge who first referred back to the 25th of March. He did it because Mr. Udin had done so. That appears, for
Yes.
example, at 1011.
Yes. No, I entirely accept that.
No, that's
And
fine.
if we check that with the transcript,
Yes.
I
No,
think
it's
we'd
correct.
find that.
Yes, indeed. He does
Yeah.
raise it. And
No, that's fine. It's just the way you were... I just wonder if there was any misunderstanding. It wasn't the judge who made the connection. He was responding to Mr. Udin having made the
no, I accept that.
Okay, that's
Whether
fine.
it was Mr. Udin or whether it was the judge, the point is that it's in the foreground again, and it would have been perverse for Mr. Udin not to have referenced it. On the second occasion, the judge raises the possibility of reporting him to the
No,
Bar
quite.
Standards Board.
I don't think there's any
But
criticism.
can I flag up a difficulty with the way we're looking at this? If I may, I mean, I question whether the linking of 3 and 8, the way you put it, because, and it does feature clearly the way you're talking about it now, but in fact, when we look at 8, there's much more to it than simply the reference to the BSB.
Yes.
And as we get it, and you're now taking us through the judge's decision on recusal, in which he refers back to other matters which are going to feature in your other instances.
Yes. No, I entirely accept. 8 is
So
a much wider
It
occasion of concern.
it is.
Yes, my lord, it is, because it has an impact, evidentially, on what then unfolds in the Guardian's evidence.
I think what my lord may be saying, if not I'm saying it, is might be more sensible to look at how the judge dealt with it after you've taken us through what the criticisms of him are.
Yes.
You know, that is what I'm querying whether it's not really for me
No,
to sit here to say this, but
no,
I'm just wondering whether.
Yes, I'm grateful for the
I mean, well, I can see why you do it,
Yes.
coming as you do to this case,
Yes,
relatively fresh, as do we. The
Yes.
strike, in one sense, the
Yes.
BSB reference is what stands out. But
yes,
for my part, instance 8 contains other aspects which, on one view, are more troubling.
yes.
Taking the time
No,
for myself.
I'm grateful for my lord.
And understanding and getting a sense of that, I think one needs to go through, to get a sense of that, one needs to go through it chronologically.
Yes, no,
Are you going to walk us through the transcript on this point?
I am going to go through the
Yeah, well,
transcript. Yes, may I just make some general points in relation to...
But I just flag before you said something in passing. Your point about the effect of the Guardian's evidence is an important point,
Yes,
which you said it in
I won't
brackets
lose
in
it.
reply.
I have
We're
much
gonna
to
come
say
back.
about that
Yeah,
in
on
due
that.
course. And I...
Well, you can tell we're keen for you to say it now, but no, I don't want to stop you doing it the way you want.
Well, I don't want to
steer
miss
from us.
points that the mother would wish me to make, or that might be relevant. And so, forgive me, my lord. I'd
No,
love to jump
of course.
on
No,
to those points, and maybe I can have a look and just reorder things so that I can deal with my lord's point more succinctly. But whilst I'm here
Yes.
and dealing with the connection point, I entirely accept and accede to the fact that it's not a simplistic connection, that it's just said on 2 occasions. It is said on 2 occasions, but in the August hearing, it is far more significant because it has, in my submission, a fairly profound impact on counsel's ability to...
Well, it clearly has an impact, if I may say so, on Mr. Udin.
Yes, on his ability to do
And what
his
Mr.
job.
I'm speculating on what Mr. Udin then says.
Yes. Yes, of course. Not only what he says, but his ability, in my submission, to do his job,
well,
and to do his job well.
and ultimately on
The witness.
his, well,
And
I
on
think my lord and I are pursuing my lord and you are perhaps pursuing 2 different points. My lord's making a point about the effect it has on the witness's evidence. You're perhaps focusing more on the effect on counsel, perhaps more accurately still on the way in which counsel's client will have perceived
Yes.
his ability, how the impact on him.
Yes.
Because ultimately, it's about, must be about, we all know it's about the fair-minded observer, but it's the fair-minded observer effectively standing in for the reasonable client.
Yes. Indeed, my lord has all three elements, which I will briefly summarise. It is fundamental to any proceedings when conducted fairly that the lay party feels that they are having a fair hearing. Of course, it's not her objective opinion. It's, as my lord says, the fair-minded observer.
It's not her subjective opinion.
Forgive me, not her subjective opinion.
Yes, quite.
Yeah, it is the fair-minded observer.
Yes.
And nevertheless, one can see how, as this episode unfolded on the 27th of August, the mother is most likely to have been very troubled. That for the second time, just connecting back, and I don't seek to make it a simplistic point, but nevertheless, she's hearing this same phraseology from the judge again, bar standards board, and it's her counsel that this is all aimed at. And then my lord makes the point in relation to the impact on counsel, because of course his job is to present the case and to do his job without fear or favour. He makes that reference indeed in the transcript. But even though he's saying it, one can see that it's having an impact on him, because he does ask for time. In fact, he asks for 5 minutes to be able to, one imagines, pull himself together.
The judge doesn't agree.
Judge doesn't agree. And we can see, although my lords don't have the audio recording of that hearing, I'm sure my lords have
Well, for my part, I wondered about whether we should ask for it, but I
Have attempts been made to get it?
the short answer is yes. I came on board very late in this case. It seemed to me it would have been a very helpful piece of evidence to have that.
one of the counsel, I think it's Mr. Bowe, says
Yes.
you had to be there to hear it.
Yes.
Doesn't quite
Yes.
say that.
Well,
But-
one can get a lot from the transcript,
Yes.
but even so, the best thing is to hear it.
Yes.
But I don't, and given the timescales, I don't think it's realistic to think that we, unless anyone says anything different, that we can get the audio in sufficient time for us to listen to it, possibly have to hear further submissions on it, depending what it shows, and still produce a decision
Yes.
that won't, in time, not to jeopardise the 23rd minute. So I think we've got to proceed with what we've got.
Yes, I invite my lords to proceed. I don't want to delay these proceedings on instructions because, of course, I submit that there is a clear flavour of what was happening at this hearing, even without the audio
Yes.
recording, because
Well,
we have...
okay, well, there we are. But in that case, we must all resist the temptation to say, well, I wish we had had it on tape. We haven't. We don't.
No, I accept that. But the point
And
I
deep down, I think we've got enough to go on, frankly.
we have Mr. Bowe's objective view. I say it's objective. He was there, he's for the child, and he clearly refers in his document to the judge shouting at Mr. Udin. He references the fact that Mr. Udin's asking for time. He references the fact that Mr. Udin seemed to freeze. All of that is highly relevant in terms of Mr. Udin's ability to put his case. And then we come to the third point that my lord makes, which is the impact on the witness. I'll go, if I may, in a moment to the transcript, but I'm just making the general points because they need to be made, that the Guardian is significantly impacted by all of this and her ability to recall what had happened the day before in her evidence. She doesn't recall, and that has an impact on the evidence she's giving to the court. And it isn't impacting in the mother's favour. I mean, that might be entirely unfortunate, and just as it is, one looking at it entirely objectively, that could have been she was asking questions that didn't help the father and she just forgot. But unfortunately, it was impacting the case in relation to the mother and Mr. Udin's ability to put his case in relation to the mother.
Well, and these are proceedings about a child and a child's welfare, and the evidence about which the Guardian was being asked was the impact on the child of being separated from the mother, a factor which is of relevance, obvious relevance, to the judge's ultimate welfare decision.
Yes.
There's decisions about residence, but in particular about contact.
Yes. Highly relevant. Couldn't be more relevant that he had an opportunity on behalf of his client to properly pursue those points and to properly put the mother's case. And so the timing of this exchange between the judge and Mr. Udin, which arises, perhaps far better if I just take my lords to the transcript and have a look at it with my lords.
While we're doing that, and forgive me for interrupting. On this point, obviously the transcript wasn't available until much later, so after the judge's decision to on the recusal and his judgment.
Yes.
And when was it definitively recognised that the Guardian had in fact said what Mr. Udin said she'd said, or something pretty close to what Mr. Udin said? That wasn't clear. You understand
Yes, no,
what I mean?
I have.
That wasn't known to, that wasn't acknowledged by the other parties or by the judge at any stage.
No.
After this incident, during the hearing.
Yes.
Was it?
The transcript doesn't seem to give rise to there being a point later on where it's clear.
I'm not criticising Mr. Wilson.
No.
Absolutely.
No, I make no criticism, of course, of anyone
but,
else.
But in other words, the judge, it wasn't drawn to the judge's attention, nor did he recognise that he'd made a mistake.
That's not in the transcript.
In challenging Mr. Udin's recollection.
No, there's. May I just forgive me, my lord?
Yes.
Yes, I'm most grateful to Mr. Udin for clarification. The short answer is that during the course of the hearing, nothing changed.
There was no acknowledgement.
There's no acknowledgement at all. However, prior to the delivery of the judgment, Mr. Udin confirms, and there was email communication, that the transcript of that day's evidence, of the relevant evidence, of the Guardian's evidence, was available to the judge. So prior to the giving of his judgment, he had, forgive me, all of Right. Yes.
Can I just make a suggestion? It might be a good idea. I mean, I can see Mr. Udin's giving you detailed instructions. It's all a complex point. If we had also gave you a chance at some point to,
yes, thank you,
to get it exactly.
yes, of course. No,
Am I following that? Is that the judge, that Mr. Udin obtained a transcript, or a transcript was obtained of the relevant part before judgment?
That's my understanding.
Was it before submissions? No.
No. So the hearing was the 27th of August 21,
Yes.
and the judgment was handed down on the 25th of October 21.
Yes, exactly.
So at some point between those
Yes.
two dates after the submissions.
Well,
were
I'm endorsing really what my lord has said. I mean, I actually got a slightly different impression from what I understood you were saying, which was that Mr. Udin himself hadn't seen the transcript, but that he was able to establish that the judge had. But all the more reason just to get this clear. You've referenced some emails. Maybe
Yes,
it
of
may or
course.
may not be important, but
Yes.
in principle we should see them if they help us establish the secret of the event.
Yes, of course, my lord. I don't want to.
Okay, well
mislead
let's move
anyone,
on
so
from this
I'll
point.
defer.
Okay, but
There
can I
will be
just-
an that well,
Just so this was if it was obtained before judgment after submissions, it wasn't available obviously when the recusal application, which was made in the course of Mr. Udin's submissions, and there wasn't a subsequent reopening of the recusal application upon receipt of any transcript.
No, there was one
I'm
application.
not making a criticism. I'm just
No.
want to get the idea,
Indeed,
the
no.
chronology clear. In my mind.
Yes, my lord has it correct. There was one application, and that was the application referred to in the judgment. But I will confirm the chronology of those matters when my lords rise in due course.
But when, sorry, just to clarify where I think you're headed on this, in the substantive judgment dated handed down on the 25th of October 2021, paragraph 99 says that in Mr. Udin's cross-examination of Shulder's Garden, he put a proposition to her which did not reflect her evidence, and then he talks about what happened next.
Yes.
And the point is that I think what you're saying is the judge had the opportunity, in fact, to look at that and correct himself
Yes.
before writing that little line in
Yes.
paragraph
Exactly.
99 but didn't.
Yes, exactly. Because, of course, my lady, the submission we make is
Is that it was
the
substantially
transcript.
right?
Yes.
Because it's
supports
really to do
Mr.
with the
Udin's
word
position.
trauma, and the word trauma was used.
It was used, and I know that Mr. Bowe makes a slightly different point in his submissions where he says, well, it wasn't quite, I'm paraphrasing, but it wasn't quite the same. But the essence of what was being said was
Well, I'm not sure about that.
implicitly-
I think that there's a risk about taking these piecemeal. I absolutely take the point about trauma. But I do get the impression that the flavour of the question was rather different. The way the witness's evidence was summarised for the question was not in any way improperly. Didn't quite reflect what the Guardian had said. But everyone focused on the use of the word trauma and
Sorry, from Mr. Udin, the question didn't properly reflect.
didn't properly reflect what the witness had said. Not in any improper ways, but just, you know, look, you're going to take us to all this, so
Yes,
let's
sir.
do it
Yes.
when we get there.
Yes, of course. Yes,
Yeah.
yes.
But again, so just so I'm absolutely clear, I apologise to everybody. Picking up on Milady's observation about what the judge said in his judgment at 99,
Yes.
it would be helpful to know, as part of your full note or whatever from Mr. Udin over the adjournment, whether anything was expressly drawn to the judge's attention about what the witness had said, or was a transcript just obtained? Was it was it sent to the judge with comment, or was it a request for further submissions, or anyway?
Well,
Mr.
all that will
Wilson.
come out.
All that
Yes,
Mr. Wilson will be able to help that.
I can't imagine that anything was sent to the judge without
Yes,
the
of
side
course.
knowing.
No, of course.
Okay, let's move on.
Yes, thank you. Because I was going to take you then to the transcript to look at it directly.
Yes.
And I think forgive me if I pull it up, I think it's at,
370 hard
371.
copy, 377 electronic.
yeah. Yes. Is my Lord content if I can pick up, please, at the bottom of 370? It's a part-
Yes, we have, of course, it's very important we focus on the detail, but you needn't just read it all to us because
Yes, of
we've
No, indeed.
read it more than once
I
already.
intend to simply paraphrase relevant points and
Yes, quite.
draw my Lord's attention to it. But
The passage in the Guardian's evidence I'd noted is at 360. Relevant. That's where she used the word trauma.
yes, that's correct. That's where it began.
I had to word search to find this,
Yeah,
but
thank
that's
you,
where
my
it
Lord.
is,
Yes.
I think.
So the evidence the day before, the Lord has that.
The last answer, almost the last answer of the
Yes.
day before.
Exactly so. That's where her evidence originates, and so perhaps if we look just there to track it back to what the Guardian did say, and the Lord has it almost.
He must have suffered trauma and loss, losing his mother out of his life and all of his extended family, to whom he was very close. And again, I've observed that personally on more than one occasion.
Yes, exactly. That's 360D, internal page 62, and so that is what she had said. And then when Mr. Udin is cross-examining the Guardian the following day, if we could look then please at 370, the bottom of the page, picking up at around G, where he starts to reference, now you said in evidence yesterday, please correct me if you find me inaudible in any way, that A had suffered trauma when he was moved away from his mother to the care of his father, leaving behind, and then the judge intervenes. And the first thing the judge says is, if...
Sorry, just so that we can get it out front now. The reason why I didn't think it was quite accurate was the flavour of that. It may actually depend exactly how it was said.
Yes.
Was that the trauma resulted from the move to the father, rather than the emphasis being on having to leave behind the mother and the extended family.
Yes.
Now, in fact, it rather looks as though, which may undermine my concern, that may have been just what he was going on to say, because when the judge interrupted, he said leaving behind.
Yes.
But I think it was I suspect what triggered the judge was the suggestion that it was something about moving into the care of the father that caused the trauma, which wasn't what the judge.
No, indeed.
But I think you'd be entitled to say, well, if the judge had listened to the end of the
Well,
question,
that's the point.
he might have realised that wasn't the flavour of it.
That is
That's the
exactly
point you're trying to
what
make
I
it
was
give
saying.
it.
No, well, there you are. It just shows.
Allow the council to...
But anyway, that's what I was getting at when
No,
I
I
was
understand.
earlier,
Okay.
and I see now
Yes.
what the answer to it might be.
Yes.
Yeah, thank you.
And so, of course, the intervention of the judge then has the impact of, I'm going to submit, distorting the evidence from the day before, and because the judge, his introduction into this exchange is that the Guardian said that if the Guardian said it, I didn't hear it. And we know that she did say it because we just looked at it.
Yep.
But it gets worse, doesn't it?
Yes, it does. Yes.
Because it's one thing to say I didn't hear it. I mean, that factually may be absolutely right. He didn't hear it, or he missed it. He didn't recall her saying that.
Yeah.
But his third intervention is, well, she did not say it.
Indeed, exactly so. My lady has the point.
In between, I think, just to get a balanced picture of what may have annoyed the judge was the tone of Mr. Udin's statement. What would you like my lord to do? For me not even to ask the question because your lordship hasn't heard it. That perhaps could be less provocatively expressed.
No, I accept that, my lord. I would submit that it was a difficult hearing, and there were certain challenges in this particular case. There are cases that, as an advocate, one is presented with.
It's not always easy, is it?
Not always easy, and to get the balance right of being fearless and doing your job, but remaining respectful in the heat of the moment, when you might feel undermined in a particular point that you're trying to fairly make to an important witness, one might get the balance slightly wrong. However, with great respect to his lordship, that should not have impacted on his lordship in the way that it did. Firstly, the intervention, I would submit, was inappropriate. His lordship got the wrong end of the stick at the very least. And then we have his lordship, as my lady points out, saying, well, she didn't say it. Well, indeed, she did say it. We know she said it. And so it's now influencing the evidence and the course of the evidence and how the evidence will unfold. And then Mr. Rudin's response, well, let us hear what she says then. Again, perhaps...
That seems to be what really triggers the judge, doesn't it?
Yes. Perhaps...
It's a combination, I mean, you can go without hearing, without being there.
Yeah, exactly. I mean, this bit really does speak for
Yes.
itself. We needn't read it all out.
Yes.
It's quite clear that
Yes.
yes.
Yes. And I've already dealt with...
things took off at that point.
Yes, the point at C about needing time, not having that time, and then, of course, the exchanges between the judge and counsel. Very difficult situation for counsel to deal with, and trying to get that balance right when one might feel as though you're losing grip of the case, the evidence, being able to do your job and simply be allowed to put your questions fairly, had a significant impact in this case. The personal consequences for counsel, in my submission, are not relevant. One is presented with all sorts of situations that one has to professionally deal with, but the impact for the case is highly relevant to this appeal. I don't say that lightly because, of course, I'm very mindful of the fact that the focus is now upon what guidance is provided to the judiciary, and I say that respectfully, about the treatment of those that appear before them, and that does include counsel. There is focus on well-being now at the bar, and that isn't just well-being that we're not asked to work extraordinarily long hours, it's also well-being in terms of how we're treated. Judicial bullying is now the subject matter of focus as well, and all of those things are relevant, but the focus of this case, of course, and the appeal is not on the basis that Mr. Rudin was upset and he was mistreated, it's the impact it had on the presentation of the evidence and his ability to do his job.
Well, yes. Can we be clear about this just for analysis? You certainly could put it that way in principle. But actually this is, as I understand it, has now been developed not so much as a case about fairness, which anyway would really be concerned with the outcome of the hearing, but more about the appearance of bias. They're not, there may be an overlap, but they're not quite the same thing.
Yes.
And it's been presented, and none the worse for that, but been presented not so much as about whether or not Mr. Udine was put off his stroke, but about what a fair-minded observer would think about the attitude of the judge to ultimately the mother and her case.
Yes.
But of course, if he was said to treat her unfairly because he'd taken against her counsel, that would all be part of the same thing.
Yes, indeed.
So I think if you really want to make submissions about the impact on Mr. Udine or how the evidence of the Guardian may have been affected, that is rather a slightly different way of putting the challenge, and not ultimately relevant, is it? Because the relevant point is whether the judge would be perceived as potentially biased against your client.
Well, my lord, that is the legal test, of course. But putting him off his stroke, which I submit is what was happening, is also relevant to that whole exercise, because it's his ability to present his case and for the mother to have a fair hearing. It all feeds into the same principle of fairness, not strictly the legal test.
No, I acknowledge there is an overlap, but so suppose it were the case, and some might say it was the case, that Mr. Udine, after an initial clear upset, actually regained his composure and went on, and the hearing went on, and all the right points were put. That might be a complete answer on fairness, and would mean we'd have to look at it and search quite a lot.
Yeah.
But it would not be a complete answer on recusal.
No, I agree. I
So that's why I just wanted to keep
Yeah.
the focus really on how the judge behaved and the impressions that would have been got from how he behaved, rather than ultimately whether it actually put Mr. Udine off his stroke or actually affected the evidence of the Guardian in any way that it might have affected the outcome. You follow me?
That is a separate example, though, my lord has in this case, and that is the effect on the hearing, which I'll come to, but I'll separate them out for the moment. But may I just say, whilst we're dealing with that, the fairness point, that it's very hard to say, isn't it, whether Mr. Udine was able, although he did complete the hearing, he did ask questions, whether he was able to do the job in the way that he had intended, whether he was able to put all the questions.
Right, no,
that
I
he
see
wanted.
that. I see that. My only point is it's a rather different kind of inquiry, focused at a different kind of outcome.
Yes, no, I accept that, and perhaps more pertinent to one of the later examples rather than this particular
Maybe.
part.
Anyway.
For my part, reading it, I didn't get the impression that Mr. Udine was certainly perturbed at the moment when it happened. And I didn't get the impression, reading the whole transcript that I've done, that Mr. Udine was unable to put his client's case.
Well, I don't want to give evidence in this case,
Well, you wouldn't be giving evidence.
of course, I've spoken to Mr. Udine about the impact it had upon him, and if my lords wish to hear what he says,
I think
can
not
also
is the
sit.
answer.
I mean,
we don't wish to hear that. But in
the-
a sense, that shows why I may be being pernickety
No, I'm sorry.
about it. We'd be having a quite different inquiry about whether the outcome of the hearing was undermined because of this episode. We would have to look at all sorts of things. We might have to hear, in principle, evidence from Mr. Udine, in which case he couldn't appear as counsel. I just don't think we need to go there,
No, I'm sorry.
and we shouldn't go there, given the focus of this challenge. This is a recusal challenge on the basis of the conduct of the judge. Now, of course, you can say the conduct was unfair because it's the kind that was liable to put counsel off his stroke, or maybe liable to distract the witness. But we don't ultimately have to decide whether it did.
No, I accept
That's
don't
why
have
I'm
to
just
make that distinction.
trying to be a bit careful about that. And that's why, with all respect, I don't think we ought to be hearing your account of what Mr. Udine may or may
Well,
not
my
have
lord,
told you about the
I
impact
entirely
on
accept
you.
that, and I've been very careful not
You know, you've done it absolutely fine. I just,
No.
I think this has been a useful exchange, but let's
Yes,
keep
I'll
going.
move on. I
Yeah.
have the point. My lord is looking to focus very much on the legal test. I entirely understand that. The point I've made, and I'm not going to advance it any further, is the point about fairness having an impact on the course of this hearing. And that is perhaps more relevant in terms of how the Guardian then goes on to answer her questions, or not, as the case may be. And so, my lords, have the point about trauma. We've already considered that at B. The word trauma was most definitely used, but of course the Guardian has gone off her stride by now. She can't recall it, and that is relevant.
Yes, this is 372.
Yes.
What she says is, I think you're probably misquoting me.
Yes.
I don't remember using the word trauma. I'm not saying A wouldn't have suffered trauma, but I don't recall saying that in evidence yesterday.
Exactly.
And then there's a further exchange about whether the word trauma was used.
Yes.
And then Mr. Udine asked, well, okay, leaving that to one side, how do you think it's affected A? Open question. And she gives a different answer, which doesn't use the word trauma.
Yes.
Describes more precisely the impact she thinks the move had.
Yes. And so, of course, because she doesn't recall it, and this line of cross-examination can't be advanced.
Well, that's not really fair, is it? I mean, she just doesn't recall it, but she does say, by way of a double negative, I'm not saying he wouldn't have suffered trauma. I just don't recall saying that in evidence yesterday. So that is saying, I think he would have suffered trauma. I haven't said so till now. And then he goes on to explain what the effect on him was, and she doesn't use the word trauma again. She talks about confusion.
She gives more detail. Trauma, in the sense, was just a label.
Yes.
And it may be Mr. Udine was going to ask, what did you mean by that?
Yes.
By trauma, which in fact is what she then does.
But
And
it
of course, the
doesn't.
end result is that she's endorsing the judge's comment that he misquoted her.
Exactly. She's endorsing the judge's comment, and it's, in my submission, weakening the way that the line is being pursued, because the judge has intervened, the Guardian's off her stride, she's not now recalling. Of course, one isn't there in the courtroom, but had there been no intervention, most likely the Guardian would have just got on with it, and Mr. Udine would have been allowed to get on with
I
it.
think my lord's point is, yes, that's true, but she might well have said the same things.
She might have done.
Because suppose the
I
judge
think
had...
if the whole of that page out, without the offending page, maybe Mr. Udine said, would have said, what do you mean by trauma? And she would have given the answer that she gives at CD. And
Yes, she might have.
And,
Yes, no, I
it's, in a sense, as I said, trauma is just a label. What does
Yes,
it mean? And
yes.
then there she's describing in more precise
Yes.
detail the impact on A of being separated from his mother,
Yes.
which is, after all, what Mr. Udine was trying to find out.
Indeed, no, I accept that. I accept that.
The last, in a sense, the lasting damage, arguably, may be that, as I said before, the Guardian has endorsed the judge's observation that Mr. Udine misquoted him.
Yes, indeed. Yes. However,
sorry,
one,
it's just, sorry, me now, Miss Handcliffe, we will let you get on with it in a minute. But I don't think I'm quite as sanguine as my learned friends are here about the effect of what the judge had said. I mean, just really want to explore the answer from the Guardian, which says you're probably misquoted. I don't remember using the word trauma. I mean, to what extent do you suggest that's a reliable answer? She has just sat there listening to the judge saying she never used the word trauma. So, I mean, is you said it's possible she might have said the same things as she went on to say, but do I take from you that it's also possible she might not have said quite those things in that way, and that there might have been a different answer?
yes, I entirely. I'm trying to be proportionate in speculating, as we all are, as how this hearing might have gone. It might be she would have said the same things, but one simply doesn't know. What we had was an
Doesn't this
interference.
demonstrate, if I may say so,
I'm so sorry, Lord.
the wisdom of what I put to you earlier. Perhaps I can find a better way of putting it, but a less smart way of putting it. We are having to speculate.
Yes.
The one solid point you've got, speaking for myself, I think it is, I'm not saying anything about the ultimate outcome of the appeal, but I think it is a solid point that the judge intervened on a false basis in terms that were extremely critical of counsel. And you would say, a fair-minded observer would say that demonstrated a biased approach against
Absolutely.
counsel and his client.
Yes. It begins and ends there, really.
Exactly what impact it had is, on a strict view, irrelevant, but on a less strict view, secondary.
Yes, I entirely accept that. My Lord, I
We can-
accept that if my Lords reach that view, and that is the interpretation of the evidence, and I invite my Lords to conclude that, then it really begins and ends there, because the test is then...
Yes, I'm not saying I have reached
No, I understand. I understand.
But I do think it seems to me that is the real point. Does the judge's intervention
Yes.
reach that threshold in terms of the impact on an objective observer?
I say unequivocally it does.
No, I know
And
you.
but my lady's point, if I may just briefly address it, yes, I entirely accept that the judge's position in the courtroom is powerful. Of course
Right.
it is. He's making the decisions in the case. What he says affects everybody in the courtroom. It affects counsel, it affects the witness, it affects the direction of travel, and the guardian
It's derailed. you could say.
derailed. Doesn't stand up for, or at least say something different. She
And to
adopts
pick
it.
up my Lord Justice Underhill's analysis of it, what you'd say is she may have been derailed, but somebody sitting in the court, an objective observer, might think, in her giving that answer, well, she would say that, wouldn't she? Because she's just had her lead from the judge on that point.
Exactly. Yes.
Of course, please don't. We're just testing
No, I
different. You're testing your points. You can't just read this passage in isolation. The temptation is to read it in isolation because it clearly was a big moment in the case. But you can't read it in isolation. You have to read the whole transcript. And then it all went on. The hearing went on, and Mr. Udin proceeded to cross-examine, question the guardian
Yes.
on other matters,
Yes.
with which it seems the judge didn't agree.
Yes. Yes, he did. And this hearing, in my submission, didn't improve or become fair following this exchange. It might have proceeded, but the course of the hearing was impacted by the events of the parts of the judgment the parts of transcript we're looking at. It was, of course, impacted. And the perception of fairness, objectively looking at that, it must be, in my submission, right, that anyone looking at this would have been troubled. One has the viewpoint of the guardian. And I adopt, may I say, so far as 3 and 8 are concerned, submissions made by Mr. Bowe, and I rely on them because, of course, his position representing the child is quite different. And if the guardian's perception in advancing that case in support of the mother's appeal is that, then she's closer to the fair-minded observer than I am in this case. And so I think that there is power in what is said by Mr. Bowe on her behalf, and that is important for the court to consider, even though she's not here represented, that Scalding argument and the points that she makes in support of the appeal are most important. And I adopt all of the points that are made by Mr. Bowe in his document.
I think I'm right, that no complaint is made about anything that happened after this.
Of the judge. No complaint of the judge.
No complaint of the judge, of anything done by the judge
Yes.
after this event.
Yes, I think the ones we rely on are up until this exchange on the 27th, insofar as perception of bias, are up until this exchange. That indeed was, in fact, the last hearing in this case. That hearing timetabled the hearing in May, and of course the judgment, as as my lady has identified, was a deferred judgment given in October. Yes. And so Mr. Uden clearly hasn't been, or indeed has anyone been before the judge since the...
No, but, quite a lot more happened on this day afterwards.
Yes, of course. My Lord, the exchanges that happened on this day...
And Mr. Uden, I'm not being oblique, Mr. Uden was able to put and elicit from the Guardian answers supporting his case in a number of respects.
Yes. Yes, no, that's correct. The Guardian...
Because the Guardian's view is that the mother... Sorry, I'm interrupting you.
No, not at all.
The Guardian's view, evidence was, that the mother was able to keep separate in her mind
Yes.
of strong feelings about the father, and what she said to the child.
Yes.
The judge was sceptical about that.
Yes. Well, the
But
judge
that was-
intervenes further.
He does, but you're not making any complaint about that.
Well, I make it in a separate part of the examples, not in this part of the examples, because the Lord will be aware that I think when we come to 9, example 9, that complaints are made.
Well, let's. Can we just do a direction on this? This has been very helpful. I appreciate that we have, to some extent, made you make your submissions in a somewhat different order, but that's, I'm afraid, how it happens. But are we there on 8? Is there more that you haven't yet, that you wanted to say and haven't yet had a chance to say?
My Lord, may I just... I think I've made the point about the freezing effect on Mother's Counsel, that's the perception of the Guardian.
Yes.
My Lords have that at paragraph 52 at 461, the bundle, which I would admit is an important point.
No,
That's her
absolutely.
bird's eye
I've written that down
observation.
already, yes.
I think, my Lord, I've made all the other points in a roundabout way, either more generally and now specifically
I
in
think
other
you
ways.
do yourself an injustice. I think we absolutely have your points on this, and that's been very helpful. Can I just ask one other question? It was the recollection of more than one member of this court that there was some authority to the effect that a judge ought not, in the course of a hearing, threaten counsel with or allude to the possibility of referring them to the Bar Standards Board, or as we think it probably was some time ago, the Bar Council. I don't have you presume if you'd find any authority to that effect, you would have told us.
I would have, my Lord, yes. I have to say I looked. I didn't come across it.
No.
But regardless of the authorities, whether there is an authority, my submission is that it's clearly inappropriate for any member of the judiciary, especially a senior member, to be making threats of this nature to counsel in this way. That's not how it should be done. If there is an issue, then it's dealt with without impacting the hearing.
You deal with it preferably after the hearing is
Yes,
over,
exactly.
or if for some reason it's necessary to do it even in the course of the hearing. You certainly don't do it in open court.
In front of the clients and everyone else that's listening. So,
Yes, well, I see all that. Yes, right. Where now?
the Lord's now looking at example 9, the different narratives to the evidence of the Guardian. Sorry, yes, the evidence of the Guardian. In a sense, there's an overlap because, of course, we've begun to look at the Guardian's evidence. May I just make a point in relation to the judge and his interruptions of the Guardian's evidence from 374 to 375. as Mr. Uden continued his cross-examination of the guardian, the judge asked a number of points as he went along. And in particular, at 374, his lordship is asking for the guardian to reflect on the evidence that she's given.
Which
It's A at 374. And a theme of this case, of course, not a point I've yet dealt with, is the mother's allegations to the police, which form quite a strong backdrop for his lordship in this case, and it's something that keeps coming back again. And in this particular...
Could I ask you about that now, or you come...
May I come back to that?
Yes,
I'll
all right.
deal with 9 now, and then I can come back to that, my lord, in a moment. But in my submission, his lordship's view of the mother's approach to the police investigation has affected and influenced how he interjects in this case, and at A is an example of that. His lordship is clearly exercised by the fact that the mother has not accepted his findings, and this, of course, is the guardian's.
Well, I did have to ask you about this if we are. There's two ways one could look at this. You might say that the judge is on some personal level annoyed that she won't accept his findings. I don't quite know whether that's how you're putting it. But you could say that a crucial question is how the mother will, in her future relationships with the children, speak about the father and the attitude she will evince about the father. And she, as I understand it, was saying, at any rate the Guardian was saying something on her behalf, that she will, whatever she may privately think about them, accept the judge's findings and not proceed on the basis that any valid criticism to the father.
Yes.
Surely it is relevant to that for the judge to say, well, if that's the case, that's really the case, why does she nevertheless keep making these allegations to the police and in other contexts as well?
Yes.
It's a perfectly valid area of inquiry by the judge, isn't it?
I accept that it is an area of relevance and inquiry. My submission in relation to that is the manner and the force with which this area is dealt with, and the focus that is placed in the way that it's dealt with. Perfectly proper for the judge to say, this is a relevant area, I want to hear about this, I want to know why you haven't accepted my submissions and why are you going to the police. But it's the vigour with which this issue is pursued that is the troubling feature.
And so I understand that distinction, and you only have to read the transcript to see what you're referring to. But why is that? What does the fact that they're pursued so vigorously show about the attitude of the judge that supports an application to recuse?
Well, there needs to be balance and proportionality, and balance even from the bench in terms of how a point is made or pursued. Of course, one might say, well, the judge was making it very forcefully because, of course, he wants to give the mother every fair chance to reflect and understand that he, the judge who's going to decide this case, takes a very dim view of this. I entirely accept that point and understand that point. But when one has that point, one has to consider where it's tipped over into pressure on the mother. Is he pressurising her? Because in this particular case, the judge is very irked by the fact that the mother has raised these issues, pursued the father in relation to all sorts of matters, and is he trying to get her to say something in the witness box that supports, forgive me, my lord, I may be saying this very clumsily, but that gets her to accept that she has lied, that she has misled. Of course, the other side of that argument is that there's then uncontrovertible evidence that she's lying and misleading the court. So one simply doesn't understand where in that balance this is all going. Has it tipped over into something else? Is it simply that the judge wants to give her this fair chance to reflect and make the point? Or is he putting her under pressure? And if so, why is he putting her under that level of pressure?
So you already are putting it, and again, I don't mind this, I'm just trying to analyse it. Look, there is an element of, I'm not sure what the noun is, from irked, but he didn't like the fact that she wouldn't accept his findings.
That's my submission.
She and all that is the mother, not the guardian.
The mother.
Well, if we're looking just at this passage in 374 around here, I'd interpreted all that exchange with the guardian. And I thought that's what you were talking about when you talked about vigour.
We then went off.
Yeah, it's my fault. I don't think it's totally my fault,
No,
because
no,
actually, you 374. You were saying this is another example in the questions he's asking the guardian of what you're going to show us. He asked the mother herself about his attitude to the fact that she hadn't accepted his findings.
Yes, that there was.
He raises it with the mother in very vigorous terms. Now he raises it quite vigorously with the guardian.
Yes. So
it is really the same point in a different context.
Exactly so. Yes.
And his challenge to the guardian, as I read it, I'm maybe oversimplifying here, so please tell me if I am, Sanctive. At the bottom of 373, the guardian says, all of her allegations, the court didn't uphold those, but that doesn't take away how she may feel she was treated by her husband in day-to-day life, and that's okay to share that with whoever she believes is the relevant people to share it with.
Yes, exactly.
Okay, that's what he picked up, and the reason he picked it up was that it wasn't just that the court didn't uphold the allegations, but the court had specifically found that she fabricated it.
Yes.
Which undermined, the judge clearly thought, the guardian's analysis, or what the guardian was saying about that. That there was in some way notwithstanding the fact that there are his findings, some validity in what the mother was feeling.
Yes.
And the judge did. And that, insofar as that fed into the guardian's overall analysis on welfare issues, wasn't the judge entitled to challenge her? And dare I say it, perhaps challenge her quite vigorously about that?
I entirely accept that the judge is entitled to challenge her, and it is relevant. But again, it's the vigour with which this is pursued, because if we read on from her answer and his lordship's intervention, we then see, and although you can't see that Mr. Justice Keehan's name next to all of the questions, it does appear that question B is still his lordship speaking, free to go around repeating those false allegations. And so his lordship is pursuing it. And I would submit putting the guardian under some pressure. And then it carries on through that page. I found that to be a false allegation. And so it's not that he has made the point and is entitled to, but the whole of this page, the judge is pursuing the guardian on this issue. Mm-hmm. My submission is that that is the same level of vigour, perhaps not quite the same level of vigour that he pursued the mother, but it is with a disproportionate level of force that he is pursuing the guardian on this issue.
Maybe this was a point you were going to make. I should go on with it, but perhaps there's some significance, given we don't have an audio of, at F, he doesn't say, have you read the fact-finding judgment? He says, have you not read the fact-finding judgment? It's difficult, if that's an accurate transcription, to say that in a neutral way.
Yes. It puts the guardian on the back foot, because she's now defending herself, saying, yes, I have. And again, the whole of this page in my submission supports that the judge is not getting the balance right in terms of the interference with the evidence. It's not simply, as he quite rightly should and is within the ambit of his judicial exercise to pursue points, to make clear those points, as my lord says, maybe with some follow-up. I'm not suggesting that he asks the question and then he just has to stop, but the whole of this page, in my submission, when read, suggests that he is pursuing this with some vigour, and this is impacting on the way that the evidence is coming out, and the Guardian being now on the back foot, having to defend her position to say, yes, I have, and the judge continuing to pursue that. And it goes on into the next page until Mr. Udin asks at 375, B, may I continue?
Yes, and you obviously place some weight on the earlier passage where the judge says, so you're speculating, when you say there may be other matters, and
Yes, exactly.
she gives an answer, so you are speculating.
Exactly. And then when we get to 376, his lordship is back in again, questioning the Guardian again. Do you have experience of a case ending, i.e. the fact-finding element, and then one of the parents going off to the police to repeat what are found to be false allegations? And so this issue that's obviously very much exercising his lordship in the
He
background.
doesn't get the answer I think he was expecting to that.
Doesn't get the
Yes,
answer he
no.
was expecting to.
And I first read it, I'm sure probably wrongly, but it's better just check. I thought there was the last person speaking was Mr. Udin, and I thought that was a question to him. I didn't think it was a question to the witness.
Yes, it's to the witness. My reading of it is that it's the Guardian.
No, now I looked at it again, I see that's more likely.
Yes,
Yeah.
So this is the top of page 376.
376. Exactly.
The question is to the witness.
The question to the witness.
Yes.
And then the judge is back in,
And then it carries on.
taking over the questioning, pursuing this issue that exercises him about complaints to the police, and asking the Guardian if she has experience of this, and then asking her to reflect in the break about it further.
Yes, obviously it's the Guardian.
And then, if I may, just in relation to the Guardian's evidence, the impact on the Guardian is a point I think that we've explored in the submissions made in relation to 8. But under this heading, if I may just very briefly say that the impact on the Guardian of his lordship's intervention in the evidence is that it affected her ability to answer the questions, and that's the trauma point that we've explored, but forgive me for repeating it, it's under this heading that I also make that point.
The answers we looked at whatever page it was, 372, was it?
370, yeah. Yep, 370. So I rely on all of that exchange under this heading as well.
Yes, I mean, not a very apt heading. Misinterpreting the evidence, that is, in fact, the point we've already looked at 8,
Yes.
but used in its own right. And giving a different narrative to, does that add anything? What is that a reference? The passages you've taken us to
Yes.
are more on a slightly different point. They're about how the judge pursued with the Guardian the question of the mother's conduct in going to the police. Is that what's being referred to under the heading giving a different narrative to?
Well, it's the exchange at 372 with Mr. Udin about.
Oh yeah, but sorry, we've done all that.
Yeah, yeah.
I'm just trying to see if there are other. I agree. That's a different way of deploying that 372 episode. But
Yes.
you've been taking us to the evidence of the guardian,
Yes.
and the actual heading in 9 refers to the evidence given by the father.
I think it's the guardian and the father. Forgive me.
Yes, I just. It may not matter as long as we have your substantive submissions now. Parsing this heading doesn't really matter, but I just want to make sure that I've understood
Yes, I
the
think
points you're making under this.
My
heading.
lord has the point. It's an overlap,
Okay.
and then it's the evidence of the father as well, which is the point is a short one. But the mother's perception was that the judge was treating the father differently, and my lords have the. My lady has the examples of the judge's intervention in the mother's evidence, particularly in relation to.
Well, that's a different heading. We got that at 7.
Yes, I'll come to that if I wait. It may in relation to
Yes.
the. Yeah.
Well, as I say, it doesn't really matter whether the heading is perfectly worded. I just want to make sure I've understood the point being made. And
Yes.
so far, I've understood all the submissions you're making. So.
Yes, I think my lord has the point in relation to the different narrative point, which is this point 9. I mean, it overlaps with 7 as well, treating the father differently. If I could make those 2 points together, and my lady can distinguish whether there is a separate point or the overlap is complete. But the point is this, that when one looks at the transcripts for the August hearing, the treatment of the father, it is submitted, and the perception of how the father is treated, as viewed by the mother, is different.
As viewed by the mother.
As viewed by the client, in this case, in terms of the fairness and how the hearing is proceeding, it is different.
Is that what the test?
No, this isn't the test, and forgive me, my lord, for coming back to a point that I know my lord raised with me earlier, asked me to focus perhaps on the real test, but it's the backdrop of this case, and so my lord, forgive me.
Well, I think, of course, in one sense, it's the backdrop, but I'm afraid it is very common for unsuccessful litigants who are criticised by the judge to feel it was unfair. So, although I have no doubt that that is what your client feels, that's why instead we focus on what the objective observer
Of
would
course.
have thought.
No, I accept that.
So I think just telling us how unfair your client finds it, I don't want to be in any way disrespectful to her, but is not ultimately what we have to
No,
decide.
I entirely accept that. My lord, may I reframe it? Of course, that is her observation, so forgive me for beginning there. Perhaps I should have put that secondary. But objectively, when one looks at how the father is dealt with in the course of evidence through the transcripts, I would submit that the father is treated differently.
But the objective observer would bear in mind what had gone on in the proceedings and the findings the judge had made.
I entirely accept a very fair point, and of course one has to look at the whole picture, and I'm not seeking to put this in a piecemeal way, selecting some parts, but regardless of what had gone on before and the court's findings, whenever any litigants come before the court, they are entitled to a fair hearing, and the process that is engaged on each occasion needs to be objectively fair. And so my lord makes a very, very good point that, of course, the judge is looking at it through the lens of his previous determinations about the mother, but that should not take away from an objectively fair process on each occasion that the parents come before the court. And my submission in relation to this hearing in August is that if one looks at the occasions where the judge intervenes when the father's giving evidence, the general point I make is that he's seeking to assist the father, and when he intervenes when the mother's giving evidence, it's to make an adverse point against the mother. And so Yes, of course he's entitled to. And one doesn't expect a judge to come to the case with the slate wiped clean in terms of, in his own mind, there is no background to the case. The point of continuity, judicial continuity, is just that, so that the judge brings to the case his knowledge of the case. But that should not in any way interfere with an objectively fair process, whatever his knowledge of the case is. And my submission is, if one looks at the transcripts in August, one sees an objectively unfair approach to the mother's evidence as against the father's evidence.
Wouldn't an objective observer expect, or at least be unsurprised by the judge intervening in circumstances where the mother was not accepting his findings?
Absolutely. Of course, he's entitled to, I'm not wanting to make a circular argument and come back to the same point, he's entitled to, and quite fairly is raising with the mother her unwillingness to accept his findings. But the point is, the point I made to my lord earlier, is the pursuit of that, the vigour with which that is pursued, and the impact that might have on the balance of her evidence. Of course, my lords have in mind that even if the mother isn't accepting his findings at that point in time, that things might change. This mother hasn't appealed his findings, and my lord, as a very experienced family judge, knows that change is a process. Sometimes it takes time for a parent to absorb, digest, reflect. It might be a case where the mother will always say, well, that's simply not true, it's never happened, and the judge got it wrong. But it might not be. One doesn't know. And so the balance has to be, the judge has to be balanced in his approach.
Was there an application for permission to appeal against any previous findings in this case?
Lord, may I just turn my back to confirm? No, not at any point. No.
Yes.
And there are the interventions in relation to the guardian's evidence. If I could just give my lords the references rather than go to each of them. Question of guardian in favour of the father's case are at 374, 376, 381, 385, 387.
374, 376, sorry.
381, 385, 387. And then in the skeleton argument prepared by Mr. Udin.
So those are interventions in favour of the father.
Yes.
Is that what you're saying? Yeah.
By the
Interventions by the judge in the guardian's evidence
Yes.
in favour of the father.
Correct. And then in Mr. Udin's skeleton argument at 410, electronic 420, he raises paragraph 15 of his document, an example of the father's evidence in the August hearing where the judge intervened in his cross-examination of the father, seemingly to improve upon the father's response. And if my lords could invite my lords to look at that passage, it begins at 410.
I'm sorry, the reference in the transcript? My mistake.
Yes, the page reference in the
275, is it? 245.
it's forgive me, it's not the transcript, it's the skeleton argument at the moment that I'm taking you to. It's 410 of the bundle, 421 electronically.
Which paragraph?
It's paragraph 15.
Yes.
If you want to take it to it, yeah, on the whole, I'd quite like to see it in the
Yes, the
transcript
source
itself.
material.
I'm sure it's been accurately
No,
transcribed.
of course, my lord. The source material is at 165F, if I have that correctly. And I think that's electronic 175.
Okay, thank you.
175.
Yes. Electronic 175. Bundle reference 165.
So the passage quoted by Mr. Udin
Begins at the bottom at F.
it absolutely starts at F. Yeah.
Yeah, and it goes on from F165, and it's quoted by Mr. Udin.
I'm sorry, which Where in Mr. Udin's document?
Yes,
are
so,
you?
so my lord, in Mr. Udin's document, it's paragraph 15 of his second skeleton argument at page 410.
And then it's
And
the
he
source-
sets out at
yeah.
length, he sets out over
Yeah.
3 pages,
Yes,
a passage from the transcript. I was just thinking.
which is for 175. Did you say?
yes.
165.
It's
165.
165, yeah, and electronically 175.
Sorry.
And it begins at F165. Going on for 2 or 3 pages.
Yes.
And
And
all
what
that-
is it, just before we, what's the overall point about this?
Well, the overall point about this is that that the judge is seeking to improve upon the father's responses in his
Yes,
evidence.
I see.
And that is a point I think that's supported by the Guardian. She gives an example in her skeleton argument, and the reference for her support of that is at page 464, where she appears to support the assertion that that the judge was seeking to improve upon the father's response. Lord, I think that is all I seek to say in relation to 7 and 9. I've dealt to some extent with 4, example 4, pressurising the mother to report allegations of abuse to the police. May I just give some references in relation to 4, which may or may not have been covered by me, forgive me if it's repetition. But the transcript at 227, why do you repeat your lies to the police? Goes on from there to 232. And example, moving on, if I may, then to example 5, the learned judge is advising the mother, he was writing in his notebook that when mother would not give a satisfactory answer to his question. I think that's my last point. Mr. Udin raises an objection to the judge dealing with the evidence, or the note-taking of the evidence in this way, and that objection is raised at 245. My lords have that. At D, we see His Lordship saying, "I've written my notebook, but once again, you've withheld material evidence from this court." And the mother responding to that.
So, what is the criticism there? Is it that it was wrong, or that he shouldn't have, or that it was bullying in some way? So, when I say wrong, that she hadn't withheld material evidence, or that it was inappropriate for the judge to say so and say it written in his notebook. What is the criticism?
The criticism in the skeleton argument raised on behalf of the mother is, first of all, the general point about note-taking, and in this case, it is submitted that the judge wasn't really writing down.
Well, I'm sorry, that is the point that he didn't write down the substance, he only wrote down a summary. Is that the point?
I think the point that's made, and the exchange from Mr. Udin to the judge, is that when he's writing something down, it's to make an adverse remark in relation to the mother. And in particular, this point about...
Yes, I see. Sorry.
Mother, on this occasion, withholding material from the court. And the mother, as my lords can see from the reply, not accepting that. She's trying to explain that she didn't, that the court had directed for the father to file this evidence, and that hadn't happened. And she's trying to contextualise, therefore, the judge's response in this particular instance. And then Mr. Udin's intervention
Yes.
at F.
Thank you. I'm just rereading that.
So it's the selective recording of evidence, but adverse to the mother's case.
Yes.
Is the point. And that exchange, my lords, so that we have the whole exchange begins at F245, Mr. Eden raising it, and then it continues on, and in particular I draw my lord's attention to C at 246. Exchange continues C and D, and into E. And then F. Lord, may I just ensure that I haven't missed any of the points as I've taken them out of sequence? I just want to...
No, of course, take your time.
Thank you very much, Lord. Yes, my lord, I think those are the points, the examples that we draw the court's attention to. If I may just make a few points
Yes, of
in
course.
conclusion. My lord, the submission is that taking the test, the two-part test, importuned at McGill, I would submit, Lord, that I've taken you to a number of examples. Some perhaps have greater force evidentially than others of occasions where there has been apparent bias. In my submission in closing, I would say that there is a particular force in example 3, 8 and 9. And that focuses very much on the Bar Standard Board issue being raised, and then the course of evidence at the hearing of the 27th and the impact that, my lord, I've explored or sought to explore in my submissions upon the hearing on the 27th, both in relation to the Guardian and the submission I've made about the imbalance in the approach that the learned judge took to the mother and then the father in terms of intervention. And, my lord, I would submit that the line is crossed. The test, the first part of the test, in Porter McGill, is made out on the evidence that we've submitted to the court. And the objective observer, the second part of the test, the objective observer test, is also met, in particular in those instances at 3, 8 and 9. And any party who comes before the court comes with a fundamental belief that they are going to have a fair and impartial tribunal hear their case. And in this particular case, in my submission, very regrettably, the line was crossed on those occasions. And the mother has a very important hearing. The parties, forgive me, have a very important hearing on the horizon. That hearing is going to direct the future relationship of a child with his parents, in particular his mother, who is the absent parent, and the siblings of that child. There can be no more important issues to be determined And all the mother seeks is to have a tribunal that can fairly and impartially hear the case. And my Lord, we rely on the examples that, regrettably in this case, that is His Lordship, for whom I have great respect and appear in front of very regularly, got the balance wrong and crossed over that line from time to time. Difficult case, difficult circumstances, and I invite my Lords to uphold the appeal. Mindful that I haven't addressed my Lords in relation to the law in this case, but the law is set out in the Scadden arguments. My submission is straightforward. There's no dispute or challenge as between the parties in relation to the law. If there's anything in particular, I can assist my Lordships in respect to the law. I'm very happy to do so.
Thank you very much indeed. Well, if you would prefer, Mr. Wilson, for us to start at 5 to 2 rather than now, that would be fine by us. If there's things you're burning to say and think you can conveniently say in 5 minutes, that's fine as well.
No, 5 to 2 is fine for me, my lord.
Very well, we'll say 5 to 2. And I can't imagine there'll be any difficulty about timing, will there?
No.
Court rise.
Yes.